Hello, everyone. Good morning, and thank you for joining us for the Copyright Office's celebration of the World Intellectual Property Day. My name is Alicia Morrison. I'm co-hosting this event with Lisa Marfa, who is also online with me, and we are both working in Public Information Education Office of the Copyright Office. So thank you for being with us. To start us off, let me introduce the Register of Copyrights and the Director of the Copyright Office, Shira Perlmutter.
Thank you, Alicia. Good morning and welcome. I am delighted to join in celebrating World IP Day. This year's theme, IP and Youth, is an exciting choice. As is often said, today's youth represents our future. Young people are emerging as thinkers, artists, and entrepreneurs, and are leading the way to cultural and scientific progress. So this morning, we celebrate these young creators as we talk about the intellectual property rights they can enjoy. This is a particularly dynamic time for society, marked by new and different ways to explore and communicate creative content. Over the past 2 years, we've all had to transform our approaches to sharing cultural expression. And young people, with their willingness to experiment and their technological skills, have led the way with all kinds of virtual and interactive performances and exhibits. I applaud the young professionals who have found a way to innovate and evolve artistically in this challenging environment. Young people have shaped culture for centuries. To give two famous examples, Mozart composed his first documented composition, a minuet and trio in G major, when he was all of 5 years old. And Picasso painted his first known work, Le Picador, when he was 9. And more recently, turning to the last century, Duke Ellington, whose name adorns the school some of you attend, wrote his first composition, Soda Fountain Rag, at age 15. Selena, known as the Queen of Tejano music, recorded her first album with Selena y los Dinos at age 13. And author Kat Zhang started her first novel at 12 and sold her young adult trilogy, The Hybrid Chronicles, to a publisher at the ripe old age of 19. These are just a few of the extraordinary artistic talents who started their careers early. Their 20th century works are all registered with the Copyright Office, and I expect that more than one creator that we hear from today are already on our list or will soon be added to it. Education is an important part of this story and a way to reach young people who may later become professionals. The Copyright Office has partnered with WIPO to develop international approaches to teaching primary and secondary school students about copyright. The more we educate young creators, the more they can contribute to global culture today and tomorrow. And of course, copyright is for all, regardless of age. It's easy to apply online for a copyright registration here at the US Copyright Office. But if you have questions, our Public Information Office is available by phone or email or in person. And we're working on a new enterprise copyright system with user-friendly technology that will make it even easier for everyone to benefit from all of the office's services. I also encourage you to visit our new exhibit, Find Yourself in Copyright, which is on the 4th floor of the Madison Building of the Library of Congress, and also viewable online. And the exhibit tells the story of what copyright means for individuals. Now, as you participate today, I hope you find inspiration from our eminent presenters and panelists. My colleagues from the Copyright Office and WIPO, the US Patent and Trademark Office, and the Copyright Clearance Center have planned a terrific program to illuminate the benefits of intellectual property for young professionals. So let me close by wishing everyone a happy World IP Day, both to the young and to all of us who look forward to enjoying their creations. Thank you.
And now we will hear from George Durani, the interim head of our Public Information and Education Office.
As Registrar Perlmutter mentioned, we are happy to present a fun and informative new exhibit on the 4th floor of the James Madison Building in Washington, D.C. And you can see selected excerpts of the exhibit on our website copyright.gov, so you can enjoy it in person or from afar. The exhibit explores how copyright law evolved and how it incentivizes creators of all ages and enriches our national culture. We've joined the World Intellectual Property Organization in celebrating World IP Day since its inception, and it's really thrilling to embrace a theme so full of potential and possibilities. The very first US federal copyright law, enacted in 1790, was called an Act for the Encouragement of Learning. So in that spirit of learning, we're here today to learn from each other. We're all on a journey together to enrich each other with creative possibility. And on this special day on which we celebrate IP and youth, we are embracing our current hybrid world situation. So in addition to this online event, we also have in-person activities that we're hosting. Yesterday, we welcomed high school students from the Duke Ellington School of the Performing Arts in Washington, D.C., who visited our offices. They toured our new exhibit. They discussed copyright concepts with our staff specialists, and they toured the magnificent Jefferson Building. Today, we're welcoming students from the Metropolitan School of the Arts in Alexandria, Virginia. They'll be participating in a similar program and performing a pop-up concert in the Library of Congress Great Hall. You can watch a live stream of that performance on our Twitter channel @Copyright Office at about 1:10 p.m. Eastern Time. That's @Copyright Office on Twitter. So I also encourage you to let today's events be a launching pad in your further exploration of the intersection of copyright, creativity, and innovation. Listen to our guests, ask questions, and after we're done, explore and learn more. You can find a wealth of information, videos, blog posts, and other resources on our website, copyright.gov. And you can always feel free to contact us if you have any further questions. So with that, I wish you a very happy World IP Day.
And we will now hear from World Intellectual Property Organization, Altai Tedlan, Desta, head of the WIPO eLearning.
Thank you, Alicia. Thank you, George and Shira, for inviting me today, and World Intellectual Property Organization. My name is Altai Tedlan. I serve the World Intellectual Property Organization, or WIPO, in Switzerland, in the capacity of head of distance learning program at the WIPO Academy, which is the training arm of the organization. I'd like to thank you again for inviting WIPO to join you for Intellectual Property Day, which we have themed IP and Youth, Innovating for a Better Future. And I'm looking forward to sharing with you how other countries are celebrating this event today around the world. There is a tradition that, as the World Intellectual Property Organization gives a theme to this, to a common IP topic, that member states bridge this topic by linking it to specific aspects that they deem appropriate. So I'm equally excited to be sharing the US Copyright Office's segment of the World IP Day, Engage Your Creativity, Copyright and IP for Young Professionals. This year, young people are the center of World Intellectual Property Day because young people are the untapped resource and energy of the world economy today. So today, I would like to share with you some of the activities that are taking place around the world. Let me give you some examples of these, of which many exist, and Shira has mentioned some of them. Some of the exciting inventions and inventors as young people. At age 14, Santiago Mena Lopez, of which in Peru, from published his first novel and is using his copyright experience to encourage his peers to complete their writing projects and become authors. Nima from Oman, at 14 years old, has filed a patent this year of a biodegradable plastic using locally available water, rice water, and fish scales. Salome, 15, Tateshville, 17, and Tamari from Georgia together created a mobile application that revolutionized tourism in their hometown, Samske Jovaketi, a place that you may now know if you Google it. They intend to make local tourism of their town easier and bring business to local shopkeepers and restaurants. Do, Tran, and Nguyen of similar age from Vietnam designed an air purifying respirator to protect COVID workers from the virus. They intend to make this invention accessible with some licensing agreements, with simple licensing agreements. We take these inventions and their purposeful goal and intentions, which I highlighted, to very seriously. We envisage a global culture of increased participation from young people as storytellers and solution finders. As you may know, there are 1.8 billion young people in the world today. In all regions, young people are natural agents of change, and in intellectual property can support their efforts to achieve economic empowerment and to obtain knowledge that will help them shape and revitalize a vision for a fulfilling and sustainable future. As you may know also, about 90% of young people live in developing countries where an increasing number of people are becoming aware and using intellectual property as a necessary economic development tool. Like us, most of them are celebrating today World IP Day through diverse activities such as workshops and seminars, competitions, and are bringing together policymakers, academics, entrepreneurs, innovators, creators, and from many fields, such as fashion, music, visual arts, filmmaking, engineering, and as well as teachers and educators. They are examining the trends and challenges, debating how best to bring young people, how best to bring intellectual property to young people, including from primary school to young professionals, displaying the contribution of young creators and innovators. To be more concrete, let me mention a few activities today that are taking place in different continents. In Europe, in the UK, they're using a cartoon character, Wallace and Gromit, to introduce children to design and technology and to invent a way to improve an existing mode of transportation for Wallace and Gromit to tour the UK. In Belgium, young European filmmakers and YouTubers are in conversation with the EU policymakers and experts about authors' rights and remuneration and their work with online media and streaming platforms. In sub-Saharan Africa, organizations and individuals are celebrating World IP Day. In Ghana, a student member of University of Ghana is introducing his peers at a campus church gathering on how to use intellectual property to commercialize their inventions. In Nigeria, the budding innovation and creativity sector, including secondary school students, are promoting the creativity of Nigerian youth, addressing the need to nurture an efficient IP system that youth could use. The US mission, in partnership with the American Business Council and Nigerian IP agencies, are organizing this event. South Africa is busy challenging the collective management organizations to be fair, accountable, transparent about the distribution of royalties. This in particular to protect using copyright Africa's useful and vibrant creations. In Latin America, the Dominican Republic has a dedicated week, one whole week of an IP innovation fair. In the Arab region, Morocco is hosting a high-level forum and a caravan a campaign caravan that will travel 12 of its regions to demystify misconceptions about intellectual property, and in particular, trademarks, design, and patents to inspire future creators with a sense of discovery and creativity. There are so many other countries that are participating in World IP Day today, but in the interest of time, I will just close with some few conclusions, some points. It is important to address some of the challenges of IP and use and recognize the US's position and the US CO's contribution to IP and use this year. Progress to harness this huge potential of youth, of world's youth to build a better future requires answers to some tough questions and effective policy responses. Globally, 1 in 5 young people are what is called NEET, NEET stands for not in employment, education, or training. 3 out of 4 of NEETs are women. So why are economies unable to offer young people the opportunity to become economically active citizens? How do we enable them? How do we enable young people to live independent and creative lives with the support of economic and community development? How do we equip them with the knowledge and skills they need for the jobs of tomorrow? So many young people who have great ideas and expressions may not see the copyright or IP as part of their creative journey, and we have to change that. And we change that through education, as my colleagues George and Shira said. So we can shorten the distance they have between their creative spark years and their commercialization of their creativity. So raising awareness about IP can help young people, and it remains a challenge. Why is knowledge on creativity and intellectual property kept off of the curriculum of young people? Why are teachers not supported with bringing it to the classroom? We need to work with them so that young people leave school having organically acquired the necessary knowledge about their creativity and ways in which they can monetize it, instead of having specific or making extra efforts to learn about intellectual property or copyright. The USCO was very instrumental in addressing these and other important questions with WIPO Academy in their recently concluded 9 roundtable series with 14 other countries, where we exchanged ideas and know-how using copyright and other IP domains. At the end of the roundtable, countries left with a sense of self-reflection to re-examine if they're doing enough to facilitate young people's knowledge and capacity to invest in their creativity, develop their IP skills, and offer opportunities for youth to become active partners in the economy. It was well recognized that the USCO and the USPTO combined dedicated, robust, and committed efforts on disseminating knowledge on copyright, patents, trademarks, and other IP domains for the benefit of youth, as well as their teachers, who are our natural partners in this endeavor of reaching young people. So I'd like to congratulate you on using the World IP Day as an opportunity to reach the youth, and on your preparations for today, bringing your budding creators who will be taking part in the celebrations. As we celebrate today, it is together with you, we celebrate the young people, but it is also for WIPO a celebration of those institutions who have made it a going concern on how to reach young people. So we celebrate you for making IP and engaging with young people a concern. So we celebrate the activities of the Copyright Office and USPTO and the leadership you have exercised in sharing your experience, especially this year with other teachers, with other governments, as WIPO increases its efforts to step up young people's knowledge of the strong linkage between creativity and IP. Once again, I thank you for inviting WIPO for this event, and thank you for your kind attention.
We will now hear from Jaylen Johnson, who is Attorney Advisor for Public Information Education Office of the U.S. Copyright Office, and she will tell us about copyright basics.
Yes, thank you, Alicia. Good morning, good afternoon, good evening to wherever you may be in the world. I'm Jaylen Johnson, an attorney at the Copyright Office here in Washington, D.C., and I work in our Public Information and Education Department. And I'm really happy to be speaking to you all today about some of the basics of copyright. So let's dive right in. So what is copyright? Copyright is a form of intellectual property that protects original works of authorship fixed in a tangible medium of expression. This means that for a work to be protected by copyright, we have to have three things. First, it must be a work of authorship or a type of work that copyright protects. Second, if we have a type of work that copyright protects, it has to be original. And third, the work must be fixed. And there's lots of information about the other areas of copyright in the law. We'll go over some of those today. But first, let's go over those three requirements that I just discussed. So let's look at what it means to be a work of authorship. The copyright law provides a list of categories of works that are copyrightable. The words you see in bold here on the screen are from this list, and below many of them, I've listed representative examples of things that we encounter in everyday life that would be copyrightable. So we have literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures and audiovisual works, sound recordings, and architectural works. And some of the things that we encounter in our everyday lives, we may not call them these things, might be songs, books, movies that we watch, YouTube videos that we watch, things that we listen to on the radio, things that we draw, things that we see on the internet. These are mostly all going to be protected by copyright. So you don't have to memorize this list or these categories. The big takeaway here is that these categories are very broad. And many different types of works and content that we see, interact with, use, and even create on a daily basis may be protected by copyright. So while we see copyright does protect a wide and vast number of works in many categories, there is material that copyright law actually doesn't protect, that it is excluded from copyright protection. So ideas, processes, procedures, systems, methods of operations, concepts, principles, and discoveries cannot be protected by copyright. Copyright actually protects expression. And what I mean by that is that it protects the works that describe or illustrate or explain these categories, but in no way will it protect this underlying concept and categories that we see on the screen. So I want to give you an example. Let's say you come up with an idea or a concept for, let's say, a weekly video series highlighting your favorite destinations. Copyright would protect the actual videos that you create and then maybe post online, but it wouldn't protect the idea for the video series. Now that we've gone over what copyright does and doesn't protect, let's look at what it means to be original. Remember, copyright protects only original works, and when we're dealing with copyright, the word original has a special meaning that's made up of two parts. So a work is original if it's one, independently created, and two, sufficiently creative. Let's talk about independent creation first. Independent creation just means that the work came from the mind of the author and it wasn't copied from another work. So in theory, two works could be the same or even similar and both be subject to copyright protection, as long as one is not copied from the other and those similarities are really just by chance. So next up, we have sufficient creativity. Sufficient creativity requires that a work contain at least a small amount of creative expression. The word I have on the screen here is a modicum. So that means a small amount, but that small amount must be more than trivial. And to satisfy the creativity requirement, it doesn't mean that the work has to be innovative or presented in a particularly surprising way, but it also must be more than entirely mechanical or routine or what you might think of as typical. So most works that you heard about in those categories earlier are going to meet these requirements pretty easily. Some examples of works that don't meet the requirements are individual words and short phrases like names and titles. You may think of a title of a book or the name of a company. Those wouldn't meet the requirements. And familiar symbols and designs, including those things like geometric shapes that we see all the time, circles, stars, hearts, maybe a cross. Those also wouldn't be able to meet the originality requirement. But the originality requirement is usually pretty easy to meet because it doesn't consider whether a work is valuable or whether it's famous or what the work means or whether we like it or enjoy it or even how much effort went into creating the work. It just has to be created without copying, and there has to have that small amount of creativity. Now we'll discuss the third requirement that I mentioned, which is fixation. So a work has to be fixed in a tangible medium of expression to be protected by copyright. So this basically means that the work has to be written, recorded, or otherwise captured in some way. The majority of works that we see and encounter in here are going to meet this requirement very easily just because of how they're made. So think of, let's say, an article typed on a word processing document or written on paper, or a song recorded in an audio file, or maybe even a sculpture that's cast in some type of material, or like a photograph that you may take on your phone. All of these things are fixed as soon as they're created. Something that wouldn't be fixed might be, let's say you're improvising a song and you haven't yet recorded it or written it down, or you're thinking about creating a script, but you haven't actually written it yet. So that wouldn't be fixed quite yet, and it wouldn't be ready for copyright protection. Another very important part about fixation is that it answers the question, how do I get copyright protection? When does copyright protection begin? Fixation is the answer. Fixation is where copyright protection begins, and copyright protection is automatic. It begins the moment you write, record, or otherwise capture that work. So you get your copyright by creating it and fixing it. And you may have heard of registration. That is very important. It has many benefits, and I'll talk about that a little bit more at the end of my presentation. So once you know you have a copyrighted work, it's important to know how long that copyright protection lasts. And as you can see here, it lasts a pretty long time, but it doesn't last forever. Copyright lasts for the life of the author plus 70 years. And in the case of a work made for hire, an anonymous work, and a pseudonymous work, protection lasts for 95 years from the work's first publication or 120 years from when the work was created, whichever of those two periods is the shorter term. So let's think about who owns a copyright. Copyright ownership begins initially with the author of a work. In many cases, the author is the person who created the work, generally meaning that person who wrote it, drew it, typed it, created it. So in this scenario, that person who created the work is the author of the work, and that also means they're the first owner of the work. So now that we see how easy it is to create and own a copyrightable work, I hope that if you didn't realize it before now, you now understand that you are very likely a copyright author and owner. And if you're still having difficulty seeing yourself as a copyright owner, I'd encourage you to answer the questions in the blue box, and hopefully that will get you to the place where you should be as a copyright owner. So individual creators, as many of us are, all of us are, we're often the owners and the authors of our works that we create. But in certain situations, the person who created the work may not actually be the author of the work. The copyright law has a provision allowing for works made for hire. And a work made for hire is a work that's either created by an employee in the scope of their employment, or it's a commissioned work that fits into one of 9 specific categories that are listed in the copyright law. And it also has to meet other specific agreements, like it has to have a written agreement that goes along with it. So in the case of a work made for hire, the author is the employer or the commissioning party. That's as opposed to what we just learned a second ago, with the creator being the author. So it's a little bit tricky. So in those cases, the employer or the commissioning party being the author is also the owner of the work. Another path to copyright ownership is through transfers. Copyright ownership can be transferred by a written agreement. It has to be a written agreement. A verbal agreement is not enough to transfer copyright ownership. And copyright ownership can also be transferred by other operations of the law. Think about inheriting a copyright from someone who may have passed away. So now that we know we're copyright owners, we need to know what rights do we have? What rights come along with that? And copyright owners have a bundle of what are known as exclusive rights. These include the rights to reproduce the work or make copies of the work, to prepare derivative works like remixes, revisions, adaptations of a work, to distribute the work to the public, to publicly display the work, and to publicly perform the work. And specifically for sound recordings, the public performance right is limited to digital audio transmissions. Think about streaming. So now that we've seen ourselves through the eyes of the copyright owner, let's look at copyright through the eyes of someone who uses the copyrighted work. Not only are we all copyright owners, as we just learned, but we're also all copyright users. And generally, because the owner has the exclusive rights that I just discussed, we want to make sure that when we use a work, we're using it responsibly. So we either want to get authorization from the owner, this is sometimes referred to as a license, or we want to use the work in another lawful way. And we'll talk about that in a second. So first, let's talk about getting authorization. To get authorization, for example, you might get permission directly from the owner by asking them or their representative for the specific use that you'd like to engage in, or you might get permission indirectly, for example, by relying on a license that you didn't necessarily ask for, but that was still applied to your use. One example of this might be the terms and conditions on a social media network or a website, where we agree to engage in certain uses and allow others to use our works. So if your use is not authorized by the owner, you may still be able to use the work if your use falls within one of the copyright law's exceptions and limitations. And this just allows for certain uses of the author's work without the author's permission in specific situations. So most of the exceptions and limitations do give specific provisions that apply to specific types of works for specific uses. So it's not necessarily that they're just broad, widespread uses, but you have to look at the specific exception or limitation. So for example, we have educational settings where there are rules for in-person classes and online or virtual teaching. There's also what's known as the first sale doctrine, which allows the user to resell or give away or otherwise dispose of a copy that they own. And then there are also what are known as statutory licenses, basically licenses that are given under the law that allow for specific uses without the owner's permission, but the user has to pay a statutory fee and comply with other specific requirements. But there's also a more general exception that many of you have probably heard of and known as fair use. So fair use can apply to all types of copyrighted works, and it allows someone to use a copyrighted work without permission if the use is fair. It can be applied to many types of works and many types of uses, as I just mentioned. So some common scenarios where we see fair use is in criticism and commentary of a work, educational or research purposes, and also in news reporting. Sometimes we see a lot of fair uses there. But in order to determine if a use is fair, it's not enough just to have your use be within one of these common scenarios, or just to think, well, my use is fair, so it's a fair use. That's not enough. You also have to consider and balance 4 factors that are actually given in the copyright law. And these 4 factors are the purpose and character of the use. So thinking about whether it's for educational or non-commercial purposes, the nature of the copyrighted work. Is the copyrighted work something that's very creative, or is it something that's more fact-based? You want to think about the amount and the substantiality of the use. So really thinking about whether you've used a lot of the work or a little bit of the work or a very important part of the work. And think about finally the effect on the market for the value of the work. So think about how will your use affect the monetary value or the money, basically the market, the value that the work can gain. Another important thing that's really important to remember about fair use is that it's ultimately a court who makes a decision on fair use. You may think your use is fair, and a copyright owner may disagree. In that case, it may be necessary to resolve that issue. If you're not able to resolve it amongst yourselves, you might end up needing to take that to court for a decision. So it's not always the case that just because you think your use is fair, you've weighed these factors, that will ultimately be true. So the final topic that I want to cover is copyright registration. Earlier, I mentioned that copyright protection begins when a work is created and fixed in a tangible form, but copyright registration gives us certain additional benefits that we wouldn't be able to have without copyright registration. And the U.S. Copyright Office is the only place where you can register your work to get these benefits. So some of those being registration is actually required in order to file a copyright infringement lawsuit. So you actually have to have a registration or a refusal from the Copyright Office in order to go to court for your work if that's necessary. Registration can provide access to certain damages, monetary awards, and fees that are allowable under the law only with registration and registration within a certain time period. It could also, again, in court, if you need to go there, it could provide evidence of the facts that are actually included in the registration and evidence that the copyright in the work is actually a valid copyright. And as a greater benefit outside of court, registration creates a public record that includes key facts about the work that's registered. And because of this, oftentimes registration can provide information to people who may be seeking to use your work and license your work. So now that you know some of the benefits and you all can't wait to register your work, you may be wondering, well, what do I need to do? It's generally pretty simple. You just need to submit an application, a copy of your work. Sometimes 2 copies might be required, and you have to pay the required filing fee. And the specifics of the type of application, the number of works, and the amount of the fee will depend on the actual type of work that you're submitting, the number of works that you want to register with one application. So it can vary depending on your specific scenario. And I just want to say there also are options for online. Most of the registrations are submitted online, and so that's a pretty efficient way of doing it. But we do still have paper forms if that's something that you prefer or that is more necessary or appropriate for your needs. But if you ever need any information about any of this, or if you're confused at any point along the way, or even if you have questions about some of the things that I've gone over today, you can always contact us. You can always go to our website. We have tons and tons of information and resources that can help you and answer your questions. And we ourselves are always here and ready. I think Holland, I saw earlier, put in the chat access and links to our YouTube, our Twitter, our blog, and some other resources. So I'd encourage you all to engage with those resources, reach out and ask questions whenever you need. And that is my time. I thank you all for having me today.
Thank you so much, Jaylen. That was wonderful. And now about patent and trademark basics, we'll hear from Branden Ritchie. Branden is a senior counsel for domestic trademark policy in the Office of Policy and International Affairs of the U.S. Patent and Trademark Office. Hello, Branden.
Hello. Thank you for having me today. This is exciting, and I love World IP Day. So today I am going to be talking about the basics of trademarks and patents, what they protect, how you go about getting them, why you would want to get them, and I'll also be providing some resources from the PTO to help you obtain intellectual property from the Patent and Trademark Office. So first, we'll just start with the discussion of trademarks. Trademarks identify the source of products and services. And so, for example, it could be the name of a business, the name of a product, the name of a business that provides services. It can be, they can take different forms. They can be words, they can be designs, they can be words and designs. They can be, in some cases, they can be sound, or they can be smells even. Play-Doh, for example, that smell is trademarked. An example would be If you are an artist, you wouldn't get trademark protection for the artwork itself. That's where the Copyright Office and copyright comes in. But if you wanted to start a company that did artwork for folks, then you could trademark the name of your company. Um, Likewise, trademarks aren't usually the design on the front of a T-shirt. Think of trademarks as the brand name in the tag of the T-shirt or the company that makes them. So that kind of sets up the difference between trademarks and copyrights. Um, Again, they can be a combination of words or designs. You think it could be the word Nike or the Nike swoosh. They're both trademarks. Um, One thing to note about trademarks, which is different than patents and copyrights, is that trademarks are indefinite. Uh, the one requirement, one of the requirements that has to be met, is that trademarks have to be used in commerce. So you can't get a trademark and sit on it. It has to be active. It has to be being used. But if it is being used, if you get a trademark registration at the federal level, you can renew it indefinitely as long as you are continuing to use that trademark. So some trademarks have been in use for over 100 years and are still in full force. Um, when you register a trademark, you have to specify what goods and services your trademark is for. So you can't just claim the word. Let's just say I'm going to do Branden Ritchie. I can't just claim Branden Ritchie for everything. I have to be using it again. So if I was a shoemaker, I could claim it for shoes. If I did entertainment services, it would be entertainment services. It's specific like that. And like copyrights, when you get trademark protection once you start using a name, um, it's a common law right, but that type of trademark protection is limited to the geographic region where you are actually using your trademark. And I might say mark, that refers to a trademark or a service mark, but it's all trademarks. So if I interchange those, that's what it means. Um, if you register a mark federally at the Patent and Trademark Office, that's when you can use that R symbol with the circle, and it's also comes with a lot of presumptions and benefits. One is that there's a presumption of nationwide use if you register your mark with the Patent and Trademark Office. What does that mean? Well, it means that if someone tries to come along later and wants to use the same mark, they cannot do it if you've got your trademark registered. So you get the exclusive right to use that mark in the United States. Another thing is that some of the presumptions are very helpful in litigation to stop infringers from using your mark. If you register your trademark federally, you can also send a copy of you can register your mark with Customs and Border Patrol, and they can help block imports that are counterfeit goods or infringing. So that's another benefit of trademark registration. And so the next question is, when should you think about getting a trademark if you're a small business? And I understand a lot of folks that are watching today are entrepreneurs, artists, business folks that are starting or have started already. And the advice that I would give is that think about trademarks early, because a lot of trademarks have been registered already, millions. And so as you're coming up with a name for your company or your products, and you may test those names, you may do surveys, or you may just think this is a great name, I'm going to use this. If you start to invest money in that project or that product or service or business, and then you name it, and then you go back and you decide you want to get trademark registration, and you search the database, you may find that the name is already taken, in which case some of those resources may have been wasted. So you want to think about, as you plan out your business and think about what your name is going to be for the business, you want to do that early on in the life cycle of your business. And so for those folks thinking about launching a business, that's something to think about early on. Again, because You don't want to get into a situation where the name's already been taken and you can't use it, even though you spent a lot of money to develop marketing materials and things like that. So I'm going to move on in the interest of time. And but before I do, I'll say this: we have a plethora, a multitude of resources on the USPTO's website page. I'm going to share some slides in a few minutes about that if I have time. But I just wanted to say this is a very abbreviated version of the summary of these types of intellectual property. And I just wanted to make sure that you knew that the PTO has a pretty easily navigable resources on the website there that has basics on all these things. So with that, I will talk about patents and how that's different. So patents protect inventions. They protect inventions of different types, discoveries. Here's where you can protect those processes. Here's where you can protect new products, and even improvements to existing products. That's important, and that is protectable under the patent laws. So your ideas and your inventions are protectable. They are protectable for a limited term. Unlike trademarks, which can be indefinitely renewed, patents are protectable for a 20 years, approximately from the date of filing the patent. And that's important, but it's 20 years. What do you get when you get a patent? You get the exclusive right to make, use, sell, import, license your invention. In exchange for the 20-year limited period of exclusive use of that new invention, you have to disclose that to the public. That's part of the trade-off in patent law. You have to explain what your invention is to the public. You can't keep it a secret. You have to disclose it. And that's because patent law is meant to progress science and discoveries. And so also so that other people can build on those and improve things. So it's a trade-off. The requirements for patentability are that the invention has to be useful. It has to be novel, which means new. It has to be non-obvious, which means that someone who's in that trade or skill couldn't have thought of it easily. Couldn't be something that they knew or could have known very easily. It's got to be non-obvious. And the patent application has to describe the invention. And again, that's for the disclosure purposes, so that if there's somebody in that trade, they could make that in the future when the time comes when they can make that. Or they could improve it with an invention of their own in the meantime. Why is patent protection important? Well, patent protection is important because it gives the exclusive rights to use the invention. It sometimes takes a lot of money to develop a new product. And so to have that exclusive period of 20 years to make money off of that is one of the incentives for innovation that the patent laws bring. The other thing is, if you've ever watched Shark Tank, you know that one of the first questions they ask the inventors is, do you have a patent? Why do they ask that? Because investors want to know that you have a property right that is secure and sure. And so if you have a patent, then they know that you have the exclusive rights to use that or to sell it or to import it, which means that if they invest in your business, there's a little more of a guarantee that they'll get money back. And again, this is all part of why patent law is important to encourage innovation and creativity. So, so basically, if you have an idea for an invention, you've invented something, you could go to the Patent and Trademark Office and seek patent protection. And those are the types of benefits you would get from such a patent. When should you think about patent protection? Again, early. Ours is a system where you want to get in there and file that patent after you've invented it and can describe it, because it's going to be very important to the business. If you wait, you run the risk that others could invent it. Others could file first if they've independently invented it. So it's something you want to think about very early on when the idea comes. And it's part of the toolkit of IP that you could use in your business. So I gave a very abbreviated summary of trademarks and patents. I hope that I made the distinction. Again, trademarks are identifying the source of products, businesses, or services, the names, the logos, the brand. Patents are protection for an invention, something new and novel, something that hasn't been done before. That is an invention, can be a process or a product, and many other things. When you come time to file your patents or your trademarks, this slide here will tell you that there's help at the PTO, even if you do it yourself. A lot of folks get attorneys to file, especially the patents, because it can be very complicated. And some also have attorneys to do trademark applications, though you can do them both yourself if you want to. And if you're willing to make that investment of time to learn the process, especially on the patent side. Trademarks, not quite as complicated, but still has complexities. So here you have, we have the Inventor Assistance Center at the PTO. They provide information about the patent examination process and policy. The Trademark Assistance Center, again, a public resource. Call them if you have questions about the trademark registration process. Next slide, please. We also have very tailored web pages on the website. This one that you're looking at is Inventor and Entrepreneur Resources. You can see, you may be able to see this, but I'll just describe it because hopefully you'll go to the USPTO.gov and explore these resources. But they have a tab about getting started, what to think about before you apply, how can you get help applying, and then other things too, and one of which is Entrepreneur Resources, which gives you a little bit of a list of what the Small Business Association would also help with that. It gives you a little bit of a list of things to think about as you're launching a business. And again, this is all about creativity and excitement and new things. And so we're just trying to give you a roadmap of some things to think about while you're launching your business and improving society and making things better or bringing out new products that haven't been seen before. Next slide, please. This is a great resource. This is Find Help in Your Area. Now, if you're in the United States, the PTO has a number of resources throughout the country. We'll talk about some offices throughout the country on another slide, but there is a place on our website, and it's resources in your area. Find help locally. There's a tab on the very home page that you click, and it brings up a map, and the map is interactive. And if you're from Texas, you click on Texas, and it shows you the resources that we have available in Texas to help you with your patent and trademark applications. So I'll quickly just mention some of the things that are there. We have trained libraries throughout the country who help people search trademarks and patents. Click on your state and you'll find the ones near you. We have lists of law schools that for free help people in certain cases file patent and trademark applications. That's available there. We have inventor groups that are in the different states so that you can start networking and learn from other inventors. Those that we know of, you click on your state and it's there. And we have other resources too on that page, but that is such that you can look locally to find resources, and we've tried to make sure that they're in most states, if not all. Next slide, please. We also have regional offices. We're over time, so I'm just going to say there's one in Alexandria, Detroit, Denver, San Jose, and Dallas. They're there to help you as well. Next slide, please. And then startups. So we have a specific web page dedicated to startups. And again, I understand a lot of folks online are exciting new entrepreneurs and artists and creators and inventors. Urge you to check out the startups links, and you can see that it walks you through the type of IP you might need, your business plan, how do you find funding. We can help give pointers on that and potentially engage with experts. So a wealth of resources on uspto.gov. Next slide, please. And thank you. I'll end mine there. Thank you so much for having me, and hope it's helpful.
So much, Branden, that was very helpful and educational. And now we will have a discussion with our artists who are online, and it will be moderated by Chris Canini. Chris is a host of Copyright Clearance Center podcast series Velocity of Content, and also a senior director of marketing. Our artists today are Holland Gormley, who is a painter, Akira Kramer, a musician, and Aditi Srinivas, who is also passionate about music and social change, and a high school senior in California. For any legal issues in this discussion, we'll have Jaylen Johnson, our attorney advisor, from whom you have already heard before. So welcome, everyone, and welcome, Chris.
Well, thank you indeed, Alicia Morrison. Thank you, everyone, for joining us today. I'm especially excited about the opportunity to speak with the students online from the United States and around the world. As we heard throughout the presentation, the creativity, the expression that you're doing is so important to you, to your communities, but also to the future. And we really encourage the work you're doing, and hope you'll continue to share it with your family, with your friends, with everyone around you. And, you know, I have to say too, I've been listening to these presentations. They've been very helpful, very informative. There's a lot there. You've probably heard some words like compulsory and licensing and permission and registration and fixation. And I remember having to learn some of these things myself. I'm not an attorney. I'm a former journalist and book author. But when I joined Copyright Clearance Center a long time ago, I got some of the same kind of instruction and tutoring. And I realized something. I realized that when it comes to copyright, if you're confused, you're beginning to understand the problem. All right. This is a very complicated part of the law, but it is an important part of what we do. And so with that, I want to turn to our panel. As Alicia mentioned, we have with us Kramer, who is a DC-based youth arts instructor and a musician performer by night. Kramer, hello.
Hi, how are you?
I'm doing well. We also have on board Holland Gormley. She's a public affairs specialist at the U.S. Copyright Office, but is also an artist and has a variety of degrees in arts management and be a Bachelor of Fine Arts in Studio Art. So Holland, welcome to you as well.
Thanks so much, Chris. Good to be here.
Good to see you. And we also have Aditi Srinivas. Aditi, you've got a lot of peers online. You're a community engagement specialist intern for the Copyright Office. You're studying for a bachelor's degree in political science at UCLA. And I know you're very passionate about music and harnessing music for social change. So maybe Aditi, we could start with you. Just briefly share with us your own thoughts about this passion you have around creation, particularly for you with music, but just generally, why is that so important to you and to your work in the community?
Good morning, Chris. Thank you so much. And yes, I am really passionate about music, creating music, and basically all different forms of art, performing arts especially. So having this interest has required me to have the want to share it with the rest of my community. And so I formed a nonprofit organization called Pass the Mic, which collects community submissions of music, poetry, and speeches to be published in an album centered around a social justice theme, which is then released on all major streaming platforms. And each album is centered around a social justice issue, and we donate the money we make on every album to various charities. So publishing music under this nonprofit has made it necessary for me to learn about copyright and how it works. And additionally, as you said, I am working for the Copyright Office, and I want to use an understanding of law and of copyright to help preserve creativity and spread this information throughout my community and to all artists.
Well, thank you for that, Aditi. You know, and as I was listening to what you're doing, it's great work, and I realized that it's not just that you're an artist, but you're an entrepreneur. You're a business person, and I think a lot of people don't recognize that those two intersect. They think about their art, they think about their music, and it all sounds very sort of lofty and idealistic, but it comes back down to ground, doesn't it? You have to work out the details. You've got to handle the business arrangements. Is that how it feels? You have to be both an artist and a business person?
Yes, definitely. Like running my nonprofit organization, I've definitely seen that. And it's about sharing artwork, which makes it a lot of what a business is. So that's definitely how I would put it too.
Well, Kramer, I would imagine that that's something you can also identify with. You're an artist, a performer. You've appeared around the country for Billboard Hot 100, for the Rolling Stone Live, South by Southwest. So, you know, really prominent venues. But you also do work with the Junior Academy for the Performing Arts in the Maryland, DC area, and you coach students on their stage etiquette, musical techniques, and in Prince George's County High School. So you have a day job, as you say, right? You've got a day job as an art instructor, but a music performer by night. Balancing those two must be difficult, I imagine, or a challenge anyway, right?
Yeah, I find it sometimes challenging, but it's very fulfilling. With working with youth and kind of guiding and giving them some sort of instruction and model of how to operate professionally. I always have it in the back of my mind sometimes, how do I show them the professional aspect while still making it fun, right? They see that I perform, but I also want to make it into an educational opportunity. So just keeping both of those in mind is, it's fun.
Yeah, well, that's so important, isn't it? I mean, we're talking a lot about business and legal issues, but it's fun, it's creative. And so how do you yourself keep the fun in it when it's really also work? You have to work hard.
Well, I keep the art at the forefront. I keep the expression at the forefront. Everybody has a story that they'd like to tell, and everybody has a sort of character that they build over time, and kind of exploring that with play, with theater. So I'm primarily in musical theater. I think it's easy because it's the foundation of what we're doing.
Well, Holland Gormley, you said when we were chatting earlier that you've got a dream job, but it sounds like to me you've got a few dream jobs, right? So you work in the copyright office, but you're also an artist. Talk about your work.
Sure. Yeah, thanks. So, I think that when you're an artist, the work never really stops, right? Because the creativity never stops. During the day, I work as a public affairs specialist, helping creators understand how to protect their intellectual property. And then at 5:30, the painting starts, right? So it's a dream job in that I'm getting to work with this community that I feel very connected to. And then, in the evenings, then I'm like continuing to use my creativity in my own paintings, right? And in my own painting business. So I think that one thing that perhaps our audience might think of is how they can engage their creativity in ways that they might not have thought of, right? Like that your creativity can come out in numerous ways. And, as we've heard from our speakers today, it's important. It's important to protect your creativity. It's important to protect your inventions. And it's important to be creative, right? In today's day and age.
Well, your work at the Copyright Office is answering or helping to do research around a lot of questions, the kind of questions that I'm sure people in the audience have, and just remind people that attendees here, students and everyone, that if you do have a question, to use that Q&A section on the Zoom screen, and we'll try to get to as many of those later on. But I suppose, Holland, when you help to answer those questions, you're really seeing the anxiety, if you will, that people worry about these things. They want to be sure that they're doing the right thing. Talk about that. Talk about sort of what it takes, and probably also maybe kind of help us relax just a little bit. This is not. We don't have to worry too much about this, right? It's important, but it shouldn't keep us up at night.
Yeah, for sure. I mean, actually, so one thing that you said in your intro about how when creators are worrying, that's actually like a good thing, right? Because they're starting on their journey. And sorry, I should say we all, right, are starting on our journey of understanding copyright and understanding intellectual property. I always like to tell creators, you have to know what you don't know, right? Even just thinking through questions you might have about how to protect your work is a really important first step. And we have a lot of resources at the Copyright Office to really help and support creators on that journey. I was plugging Engage Your Creativity, our page specifically geared towards creators earlier in the chat. I'll drop it again. We also have great YouTube videos, a number of resources for, I guess, like medium specific arts. So we have resources for musicians and writers and photographers. And we also have a really great help desk, right? Staffed by people who understand, where we're all coming from as creators, because many of them are creators themselves.
Well, Kramer, I want to ask you about that because you work with students too, and you've got your own performances and your music. And, there's an issue here around rights, which is really important. People should know their rights and should do things to, protect their rights as artists. Tell us about the process you've gone through to be mindful of that.
Well, the process I have gone through was learned by word of mouth, with suggestions from other artists, but it pretty much entails protecting things by copyright when you're performing them publicly. So when I know that I'll have a very large performance and I'm presenting work that I haven't recorded and published publicly, I'll copyright that because I know that I might want some protection on that. And then with my students and youth, we do a lot of theatrical productions that are written by other people. So we always have to ensure that we are getting the right permissions, essentially, before presenting that material.
That's right. I mean, I think a good rule is kind of the golden rule when it comes to copyright, right? If you're a copyright owner, if you're an artist or creator, you want people to ask you for permission to use your work, and you should probably do the same for them as well. So Aditi Srinivas, with Pass the Mic, there's multiple layers here. Talk about your concerns around protecting the contributors to these various projects you do.
Yeah, so being a part of or being a co-founder of Pass the Mic has definitely allowed me to be really in tune with what copyright law is, because publishing music does require us to go through certain distributors in order to be able to publish the music. And we always make it a point to make sure all of our music that is published is copyright protected. And we want to make sure that our artists have the right, to be protected from infringement and make sure that the money is going to the right place. And since we donate it to charities, it allows us to do that.
I know we have on the line with us Jaylen Johnson, the attorney who told us about the basics of copyright. And, Jaylen, I was listening to you and thinking about the students who were listening and watching as well. And I remembered one particular myth about copyright that I bet is still out there. Maybe you can clear it up for us, which is I can put my written material, whether it's a song or a short story or whatever it is, and mail it to myself. And that's protection. I bet that's still out there. Is that something you hear about? And what's the kind of basic thing people need to do just to be sure they feel comfortable?
Yeah, thanks for the question, Chris. That's definitely a myth that we still hear about at the Copyright Office. We actually have a video on copyright myths, and that's one of them that we address. So that's what's been known as the poor man's copyright. And so none of that is actually necessary to get any of the benefits that I talked about for registration, nor is it necessary to actually get copyright protection. So you keep those two things in mind, that you get copyright protection as soon as you are creating your work, fixing it, writing it down, capturing it. And then if you want those additional benefits of registration, like being able to have access to court if necessary, and also having it in the public record, those benefits you can only get with registering with the US Copyright Office. That is the only way that you can get those benefits. So you can do that, but it doesn't really do anything but cost you extra postage.
Well, I think, again, a theme that we want to stress is because this is World Intellectual Property Day, and the theme here is around engaging creativity and innovating for a better future, is really about empowerment. There's a tremendous amount of resources the Copyright Office has. I'm sure that WIPO has as well, Copyright Clearance Center. On our own website, we've got some educational videos as well. So really, again, we want to emphasize the importance of protecting your rights, but we also don't want to overshadow the importance of the creative part, right?
Absolutely. Yes, absolutely. It's very important.
Yeah.
That's where we get to copyright, through the creativity. So
Exactly. Kramer, because again, you have this really interesting dual role of performer and arts educator. Have you got your own stories to share about the innovation, the creativity that you see in the young people you work with that would inspire us today?
Do I see innovation in the students that I teach?
Yeah, I mean, share with us an inspiring story, because I want everybody to really feel that this is real. This is really happening right now.
I teach so many students. I would say that over the pandemic, I saw a lot of creativity used. Definitely the move to virtual teaching and instructing, but also adding that artistic element to it and trying to put on a play or present music via a virtual presentation is difficult, but it shows that even when people are separate, even when people aren't face-to-face, that we're still yearning for that ability to share stories and share art with other people. The students were recording videos and sending them in, recording choreography at their house, dancing in their living rooms, sending in, different artistic, modes of expression. So it was really fun. And I think that definitely shows the innovation of art.
Absolutely. Again, we were trying to intertwine the role of the artist and the role of the entrepreneur, I'll call it, right? But what you're talking about there was really entrepreneurial. People were faced with the challenge: how do I get my work out? How do I share what I'm doing? And they found ways to do it, even if they really were, couldn't leave the house at some point, right?
Right, exactly.
That's really exciting. Adita Srinivas, can you share as well any sort of inspiring stories? I mean, your own story with creating Pass the Mic is inspiring enough, but you connected to activism in your community. Talk about that connection between creativity and the community.
For sure. I think art is an amazing medium to spread messages that want to lead to social progress, and being a part of this organization and getting to experience all the creativity in my community, that itself has been really inspiring, because we did also form this in the pandemic in a time when we weren't really sure about how things would go in the future. But being able to see everyone's creativity and their messages through art has been a really inspiring thing for me. And I've grown to see so many different kinds of art that have been represented in this medium. And it's just been a great experience being able to provide a platform or like a megaphone speaker for these already amazing messages and already talented people to be able to share their work out to the world.
And you know, it occurs to me listening to you, Aditi, that it's not the audience here because it's on the internet, because it's digital, isn't just the audience in Los Angeles or wherever we are, Washington, Boston, wherever we are, but it's a global audience. And it's a creativity, expression, all of these things really, you know, connect us to people we wouldn't know, we wouldn't meet otherwise, right? It's really exciting, I think, the way it brings the world together that way.
Exactly.
Yeah. What about that? Maybe Kramer, back to you if I can. We're sort of coming to the end of our discussion here, and we've got a lot of questions to get to. But it must be really exciting for you to have not only that local audience. I know you perform a lot locally in the DC area, but you've got a global audience too.
Yes, yeah, I always take that into account. There are people that listen to music all over the world, regardless of genre, language, you know, whatever.
Right, and Holland Gormley with the Copyright Office there. I mean, there's you know, it's an arm of the Library of Congress, so it's part of the United States government. But your website, your work, your educational resources, they're accessible to anyone around the world. So is there a sense of share with us your own sense of the importance of global collaboration?
Sure. Well, I mean, no matter where you are in the world, if you're a creator, you have a really important job, right? Because you're creating and documenting and collaborating with our, you know, global sense of history and culture. There's nothing more important than being creative or being a creator. So whether you're creating in the US or whether you're creating abroad, I think it's important to understand how intellectual property laws can be used to protect your most important asset, which is the work that you're making.
Right. It's again sort of, isn't it funny? We think about art, but we don't usually think of it as an asset, you know, like a bank account or a house. But in a way, it is.
Absolutely. Yeah.
Yeah. Well, I want to thank the panel for sharing, you know, your ideas and your passion about your work and about the rights of artists and creators. And I guess now is an opportunity to get to some of the questions that we've had, and I'm happy to moderate them. Jaylen, you're there. You're the expert. We're all pretending to be legal experts here, but you really are one. So maybe you can join us for this and help us out. And I guess maybe shall I go to some of the questions? Should we do that?
Absolutely. Please, Chris.
All right. Well, thank you, Alicia. So I saw one here that kind of crosses over in a lot of the areas we were just discussing, which I'm going to try to summarize it. But the person here is doing a startup around educational visual arts consulting. And apparently there's a trademarked name. So that corresponds to what some of the materials that Branden Ritchie was sharing with us. So there is, as the questioner the attendee says, there's a commerce side of all of this, and I think this person is trying to sort out the copyright, the trademark, the business part of this. Who's the creator? You know, is it a business name? Is it you know, a corporation? Is it an individual? I don't know whether, Kramer, do you have a business that you operate as well as your own personal work? I mean, do you have to juggle a lot of different paperwork to get it all done?
Yes, I juggle a lot of different documents and paperwork. I do have my own business, Kramer Music and Entertainment, and I teach guitar lessons. I teach a lot of music lessons, as well as operate as a teaching artist throughout Prince George's County. So there are quite a few things in addition to musical performance, and you know, backing people on tour and studio sessions. There are a lot of things that go into presenting art.
I bet when tax time comes, you're not you're not very happy. I bet there's a lot of work that you have to do. I want to bring in maybe Jaylen Johnson and Branden Ritchie here, because these questions are sort of applied to both copyright and to trademark. And I think Jaylen, you said that you can, when you copyright materials, you can publish. Sorry, you can register copyright for a single work, but also for a group of works. Can you explain that? Sort that out?
Yeah, absolutely. So generally, the sort of rule per se, if you will, for works is that you're going to be registering one work per application. But there are exceptions that allow for groups of related works to be registered with one application if you meet the specific eligibility requirements. And so it really will depend on what type of work. I'll give an example. We have a group option for unpublished works where you can register, I believe it's up to 10 unpublished works with one application. But of course, all of the works have to be unpublished. And that's a question in and of itself. And then all of the works have to be of the same type. So you couldn't register, let's say, songs on an application together with books. So you could register a group of songs, you could register a group of books, but not together. Of course, you could divide them accordingly, how they would match with each other. But that's just one of the examples. We also have options for groups of photographs. We have options for contributions to periodicals. So if you're a writer who contributes a lot to publications that may go out, we have options now for literary works that are appearing online. So there are lots of different options. And this is actually where I would really encourage folks to reach out to our office, because if you explain to them what your situation is and what you're trying to register, they can really help you walk through those requirements and talk about what might fit for your particular scenario.
Right, and you can register a work under your own personal name, but I would imagine you can do it under a business name, right? So there's works that are copyrighted by Walt Disney, but then there's also works that are copyrighted by the Disney company.
Yes, absolutely. And that touches on what I talked about earlier. So with the business, you're going to be dealing with the work made for hire situation. So you either are somebody who's employing people who are creating this work, and that's a part of their job. And in that case, you can absolutely, if that's the case, your business would be the author. You would register under the business name. If that's not the case, you want to be very careful. Another tricky area, another time I would encourage you to read our resources and perhaps reach out to our office, because some of these things, as Chris, you mentioned earlier, copyright can get pretty complicated pretty quickly. So if you're dealing with creating works, either you own a business and you're hiring people, or you work for a business, you may want to just double check to make sure you're getting the right understanding of who actually owns those works.
Right. It does no harm to check, that's for sure. Yeah. There's part of this question too is about trademark, and Branden Ritchie, I think you're still there. You gave us a pretty comprehensive review of how all the trademark works, but do you need to trademark a business name? Is that a requirement?
No. You don't have to trademark your business's name, and in fact, when you start using your business's name, you get some rights to use that mark. They're common law rights, and they're going to be limited. Though the disadvantage is they'll be limited to the geographic area where you're offering the services or goods. So if you have plans to bring your product or your services nationwide, offer them to consumers all throughout the United States, then it would be advisable to think about federally registering the mark. The other thing I should mention is, because I know there are some international folks, from different countries on the meeting, the trademark and patent laws are limited. They're territorial. So that means if you get a trademark registration in the U.S., it's good in the U.S., but you would have to get a trademark registration in another country if you seek to do business there and want your name protected. You can still do business there, but if you want to have that protection there, you need to do that. Same with patents. And there's ways to do multiple countries at the same time, file registrations or applications for patents, or file for application for a trademark registration. So you can streamline it to some degree, but yeah, that you don't have to get a federal registration to use a business name,
You
but
can just
you have to be
start your
careful
business.
because I'm sorry. Yeah, you might be careful because someone could come to you and say, "Hey, you're using my mark that I have registered," and ask you to stop. So that's the one disadvantage.
Right. But I guess, again, the point is that we don't want to discourage people from doing any of this work if they haven't filed all the paperwork. It might be some people might think, oh my God, I haven't done, I need a lawyer. You don't need a lawyer to become a musician or write a novel or go into business for yourself doing work like Aditi is doing. There's a question here because people I'm sure a lot of really creative people. I know, for example, the famous example is John Lennon and Paul McCartney of the Beatles. They can't read music, couldn't read music, couldn't write a note, but all of their works are copyrighted, and so you can copyright lyrics, Jaylen, right? You don't need to have annotated music. If you've written a song, at least the lyrics can be copyrighted. Probably to copyright the music, you do have to have some notation, I would think.
Well, yeah, so that's a little bit of another could be potentially tricky area. So usually we think of a song as sort of like one piece, one thing, and we want for registration that all of the whole entire thing be registered. And so in terms of lyrics, a lot of times with songs, there are people who are lyricists or people who write the lyrics. And then you also have composers, sometimes referred to as producers, or people who are basically only creating the music. So if you're, let's say, a songwriter and you're writing a ton of lyrics and you've got like a book of lyrics and you want to register those before you've gotten together to create an entire song, then absolutely submit those lyrics, especially before they're out there in the world. Submit those lyrics. You can use those group options and group them into 10, and that will be a really good idea then. But after you've gotten together and made it into a song, you really want to register that entire song. And in terms of the format, you can submit recordings. You don't have to know how to write music, how to notate music in order to have your works protected. So it's not necessary that it be in a notated form or on staff paper or in a sheet music. You can actually submit. I've even heard, people, what sounds like you've taken like a voice note on your phone and you've hummed the tune and you've sent it in. So if that's the work that you have, then by all means, submit it for registration.
And that's fixed, which was the point you made before, right? You can hum it to yourself in the kitchen, but if you record it on the iPhone, that's when it gets fixed. We have a couple of minutes left, and I just want to ask Aditi Srinivas, because with the Pass the Mic project, you've probably encountered all these multiple layers of copyright. Copyright is one of these things that it's kind of like peeling an onion. You can copyright the song, copyright the lyrics, copyright the performance, all of these things. Is that something you've had to handle yourself with your work?
We have had to handle it, but most of the work goes through our distributors. So always using like those resources to help you with the process is really important. And there were certain links dropped in the chat, which also go into detail about the multiple levels of copyright, the layers. And I definitely recommend looking at those because those really helped me really understand what it means to protect those different aspects of art.
All right. Well, Aditi Srinivas, thank you very much for joining us today. It's really good to have you on the program. I want to thank Kramer as well. Kramer, thank you for your contribution here and for your work, not only your music, but for your work with all those students. Thank you so much.
Thank you for having me.
And also want to thank Holland Gormley, who's with the Copyright Office by day and at the art easel by night. Thank you very much, Holland
Thank
Gormley.
you so much. And thanks to everyone in the audience.
Yeah, and back then to, I guess, Alicia.
Yes, and I wanted to thank all the presenters that we still have online. Thank you so much for celebrating that World IP Day with us today. And we'll see you at our next event. Thank you so much.